Okay, good morning, everyone. I'm Jim Mooney, President and CEO of the Greater Boston Chamber of Commerce. Thank you for joining us today for today's discussion dealing with the reopening phase of this situation with the coronavirus. As I'm sure everyone on this event knows, we're in currently what the state has defined as phase 3, which allows different businesses and industries to open under different circumstances, with some left in a restricted mode until phase 4. But as the Massachusetts economy and our workplaces gradually open, employers are thinking about issues of protecting not only their employees from the COVID-19 crisis by mitigating potential exposure to infection and spread, but thinking about their own situation in terms of liability in this moment. As I have talked to major employers around Greater Boston, asking them what's on their mind, what are they concerned about, I think that almost 100% start with the protection of their employees. A great deal of concern for how do I do that, looking for guidance from city, state, and even federal officials on the requirements or the suggestions about reopening. And many of them are following all of those suggestions. But as we reopen, as we bring people back into workplaces, that means businesses of all sizes are facing liability risks. Today's presentation will discuss potential issues, liabilities, potential lawsuits that both employers and employees should be aware of. And our presenter today has a great deal of knowledge and experience in this issue. Liam O'Connell is co-managing partner at Nutter, the chair of the firm's Labor, Employment, and Benefits Practice Group, and a member of Nutter's executive committee. As an employment lawyer, Liam regularly represents clients in the litigation of labor and employment disputes in state and federal courts, providing extensive counsel on a range of general employee relations issues. Liam has a presentation that he's going to walk through, and when that is done, Liam will be joined by Carolyn Ryan, who is the Chamber's Senior Vice President of Policy and Research, to facilitate a Q&A session, have a conversation with Liam, as well as facilitate questions from the audience. Carolyn, throughout this crisis, has been connecting with our members and employers on issues that are on their mind and staying focused on what is happening at the city, the state, and the federal level, both in terms of policy, regulation, guidance, and has done a great job standing up the information that the Chamber has been able to provide. So please remember to submit questions during the webinar if something occurs to you using the Q&A feature on your screen. And with that, I'm pleased to pass it over to Liam for today's discussion.
Okay, thank you, Jim, and thank you for the kind introduction, and thank you all for having me here today. Jim and his team have done a great job during what now is 4 months into a challenging time for employers in the Commonwealth, and in my practice, we've been helping employers in all types of industries, all types of sizes, navigate through an environment that includes really changing conditions almost on a daily basis, right? So I have been asked to speak to liability issues that relate to employer reopening, but I really, in a sense, would like to look at it from a macro perspective, right? Because the liabilities take many different forms. Some of them, what we think of as traditional legal liabilities, whether they're lawsuits or government actions, et cetera. But then others, considerations that you may have that deal with employees as they're coming back, that have some legal implications as you try to navigate through the various guidelines, through benefits that now are provided to employees, new laws, new regulations, and so there's liability that's embedded within that, both in the traditional sense that the possibility of getting sued or having some sort of government action taken, but also just generally in understanding what employees may be entitled to now, what your obligations are as an employer, and obviously. And so the question I get from clients of different sizes and industries is, what are the things that we need to be concerned about now? And for each of those employers, the answer is different, right? Some of it's going to be driven by the type of industry that you may operate in, whether you're a retail establishment or you're in manufacturing, or whether you're predominantly an office type environment. Do you have visitors or customers coming onto your premises? Do you have concerns those types of third parties and them being exposed to the COVID virus, and what are your obligations as an employer, as a business, to those individuals? Do you use, for example, subcontractors, 1099 folks that are not your employees, that might not be covered, for example, by workers' compensation? How does that factor into decisions you make as you reopen and you're planning? Are you in a unionized environment, and or do you have parts of your business that are unionized? And if you have a collective bargaining agreement, what does that mean with respect to plans for reopening? And then, of course, things like your location and your employee base. Do you have exempt, non-exempt workers, a combination of the two? And what are the implications of that as you make plans? So lots of different factors that go into considerations of issues that you may be looking at from a liability standpoint. And I thought that we'd touch in general terms on some broad issues today, and then obviously to the extent that you have questions, and Carolyn will have input on this as well, we can talk about that. So I'll start with maybe a broad overview, right, as to liability issues that employers are confronting here as we're reopening. And first and foremost, we have the governor's order, right, and the general guidance and sector-specific protocols that may apply to you. As Jim mentioned, we are in phase 3 now as of July 6th. For most of the Commonwealth, Boston and Somerville, July 13th. And this looks like it's going to be a long phase, right? Because phase 4 is the phase where we have a development of a vaccine and or treatments that will enable us to move into a new normal per the state plan. So we look like we're going to be in stage or phase 3 for some time. And as you all are familiar with, there are sector-specific protocols that the Commonwealth has established for different industries. And so as an employer opening or reopening, we're going to need to be mindful of those guidelines, those sector-specific protocols, and make sure that we're in compliance with them all. Now, I suspect that that's not news to anybody on the call, and that you all are working through all of those issues if you haven't already. If you were a business that either was essential and so you remained operating and or opened in phase 1 or phase 2, you've already gone through that. And if you're in phase 3, you're in the early stages of having had your plans in place, brought people back, and are now operating under those protocols. But we need to be mindful of that. We're going to touch on a few items that certainly in my practice, I've had a number of employers ask about, including the interplay between the governor's directives, for example, on quarantining when people travel out of state, and, for example, the emergency sick leave, which was really a hot issue with a number of employers as they've sort of navigated this return to work environment, and what people are doing this summer as they make vacation plans if folks are traveling outside of the state. So that goes to the second bullet, which I broadly categorize as liability. In a sense, it's really the ground rules and how we operate with respect to our employees now in this environment are different than when we before the pandemic, and before perhaps some people were out of work for periods of time and now they're coming back. So things like entitlement to leaves and time off, that's obviously impacted by statutory law provisions that have been passed. Travel policies, do we have them? Are we going to introduce them? What are we going to expect from our our employees by way of reporting travel? Can we prohibit travel? What happens when somebody travels out of state and returns? What do we do with respect to testing and privacy issues, right? Some of those sector-specific protocols that I've referenced include, obviously, obligations for us to have a certification, self-certification by employees as a condition. Are we engaging in some testing, temperature taking, that kind of thing? And what do we need to be concerned about there? And then how do we deal with, for example, employees who may be reluctant to and or refuse to return to work? And I might add, at the end of this month, the federal unemployment subsidy is due to expire. Now, there's been a good deal of discussion about that continuing in some form or fashion. We'll see what that brings us, right? But that will alter the landscape of return of employees who may be in furlough condition, for example, and have been receiving that $600 per week supplement. Once that goes away, they are in a materially different position from an economic standpoint than previously, and that's causing some challenges for employers, particularly some employers that perhaps made use of the PPP loan program and are returning people back to work who've been placed in a furlough state. So liability issues that relate to your employee base and how you bring them back and what they may be entitled to by way of time off. What can we do by way of restricting their movement and or reporting? What can we do by way of testing? What are our obligations there, and how can I get in trouble? What do I need to be concerned with? There may be some of you on the call that are unionized, have union employees, and operate with collective bargaining agreements. But even in the absence of that, the NLRA still applies to employers, and there are protections for employees that engage in what's called concerted activity, right? So particularly in this environment, we see situations where a group of employees may be registering concerns about some workplace safety issues. Need to be mindful that that occurs even in the non-union setting with the backdrop of the NLRA and certain protections that provides to employees who are engaging in that kind of activity, which would meet the definition for concerted activity. Obviously, if you have a union and you have a collective bargaining agreement, there may be provisions in there that directly govern how you're returning people back to work and what you can and can't do by way of work rules. And to the extent that there are not specific provisions, it may well be that things that you may want to do as an employer would be what we call a mandatory subject of bargaining. And you'd have to sit down and negotiate with the union over some of the terms and conditions of a return to work and any protocols, policies, procedures that you may want to implement. And then lastly, we'll talk a little bit about potential lawsuits. There's been a good deal of press on this. The U.S. Chamber of Commerce has been out front on this. There's obviously a lot of concerns by the employers about exposing themselves to liability as they return people to work. There are concerns about OSHA requirements and liabilities there. There are concerns about tort actions, either from employees and or contractors, visitors to the premises, customers, and even family members of employees, for example. Always concerns about class actions. There are some FLSA issues that cause liability concerns, Fair Labor Standard Act and wage and hour type concerns. And then lastly, whistleblower claims, which can take place under several different statutes and several different forms. But as an example, the employee who's complaining about unsafe work conditions and feels that they're being retaliated against and might seek to bring a whistleblower claim. So talk a little bit about the employee issues first that I touched on. So we now have an environment where as we bring people back to work, we've always had, well, not always had, but we have had in the recent past, obviously the Family Medical Leave Act. We've got ADA compliance type issues that continue to be things that employers need to be mindful of. But now as an overlay on top of that, we have the employee leaves and time off benefits that were introduced as a result or in response to the pandemic, right? So whether it's the ESL, the emergency sick leave, the 80 hours that employees can take, or the 12-week period of time during which an employee can be out of work on an FMLA type leave because there is no child care available and or the schools are closed. Those are issues that employers need to be mindful of as they're bringing people back to work and as we start rolling into the school year in September and we see what the future holds for us there, right? So we find that a number of employers are working through those issues. It's been out for a while now, the laws, right? People know about it. Policies have been updated, protocols have been updated. So it's more of a being mindful of the interplay with those leaves and other requirements by the law. So for example, the employee that may have a pre-existing health condition that may make them at risk in returning to work and sort of working through the ADA compliance issues while at the same time potentially providing time off if the employee needs it and is entitled to it, for example, under ESL. As I mentioned, the ESL is also been a subject that employers have been concerned with as it relates to travel policies and employees now who have returned to work but are leaving the Commonwealth, for example, and or the New England area, right? So under the governor's order on July 1st, we don't have the 14-day quarantine directive if individuals are traveling in the New England area or down to New York and New Jersey. But we've had employers that have struggled with the issue of what do I do with the employee who goes to Florida for a week vacation and they come back. I certainly want to make sure that I protect my workforce and that I take all steps necessary to make sure that I'm doing everything I can to ensure the health and safety of my employees. And so when that individual comes back under the governor's directive, we would have that employee quarantined for 14 days. During that period of time, are they entitled to ESL because they're being asked to quarantine pursuant to a government order? That was an item that was really causing a lot of consternation on the part of a number of employers. We worked on that in the last week with the governors, with the state, the AG, and the DOL. And the answer to that specific question is that they're not entitled to ESL because it's not an order by the governor. It's a directive and an advisory. At least that's how it's being interpreted. And so in that situation, for example, an employer may require an employee to quarantine for the 14 days after traveling out of state. And they would be able to, and employers are encouraged to allow employees to use their PTO and or I'm under the Massachusetts statute during that period of time. So working through those issues and concerns about liability and not providing employees what they're entitled to has been somewhat of a challenge in recent weeks as we see some people that are traveling a bit and now returning to the work environment. And that gets to the third bullet there, the off-duty conduct and travel. What can we prohibit? What can we require? Can we restrict an employee from engaging in certain activities in non-working time? And how does that impact the work environment, right? So there are limits on this, and for every employer, the answer will be different as to what the proper process or protocol might be. Certainly, the HR professionals on the call be very attuned to the discrimination type issues that might arise in this scenario. But as a general proposition, as an at-will employee state, the employer can have work rules that do prohibit certain activity by employees. There have been a few employers that have struggled with the question of, what if I tell my employees I don't want them traveling out of state to Florida or to known hotspots, and they go ahead and do it and they return? Can I fire those employees? Do I need to bring them back? How do I handle that, right? So those are real liability concerns that we work through with employers. As a general matter, there's a fair amount of latitude for an employer, but there are obviously potential liabilities associated with some of those decisions, and depending on the circumstances and what the travel was for, we'll need to be mindful about a non-discriminatory approach to that. Other liability issues that are raised by returning employees to the workplace and operating in the present environment are the testing and privacy issues that I'm sure many on the call are familiar with, right? So what are we going to require by way of testing of our employees? Are we going to administer the test? Are we going to send them to a third party for a test? Who pays for that? Those type of issues come up as a general matter, right? If it's at the directive of the employer is going to be responsible for paying for the test and for the time that it takes to take the test. There are privacy considerations, right? That the EEOC has been out in front on this, and so if you are testing on from a medical standpoint employees as they come in, right, that information needs to be treated as a medical record. And as you know from the phased in the Commonwealth, we have self-certification requirements, if you will, that employees are going to need to make. And so you want to make sure your protocols and policies are in place to be compliant with state law there, but also to make sure that you're doing this in a manner that's not going to expose you to liability from a privacy type standpoint. And last, I touched on the FLSA issues, the payment for the tests, and the time that it takes to get a test. So for those that do have unions and collective bargaining agreements, obviously those are going to play a big role in how you return employees to the workplace. There may be provisions within your collective bargaining agreement that are going to provide governance and set forth policies as to how you would bring people back. And even if, for example, you're an employer that's had a layoff or a temporary furlough, and how those employees are brought back and in what order. The recall provisions, it's not unusual that a collective bargaining agreement would touch on those and have provisions specific to those issues. And to the extent that you don't have those kinds of specific policies within a collective bargaining agreement, generally things like recalls would be mandatory subjects of bargaining, right? So we would need to provide notice to the union and an opportunity to bargain as to how we're going to effectuate a thing like a recall. And then obviously to the extent that we now are going to, many employers that I've dealt with have unionized environments are looking at perhaps staggered shifts or modifications of shifts, right? Or staggered staffing and changes to the workstations and protocols and how people do their job, right? All of which impact potentially rights that the employees have to collectively, or the union has to collectively bargain the rights of employees in those areas, right? So many employers in a unionized setting have been working through these issues. There are some exceptions, although fairly narrowly drawn. In March 2020, the NLRB's General Counsel issued some guidance on what we call the unforeseen economic emergencies, which would allow an employer to unilaterally take some action rather than bargaining with a union. But those exceptions are fairly narrow. Some of them came out of the 9/11 timeframe. Think of with the passage of time now, employers have had an opportunity to plan for a return, to plan what changes might be required in the workplace. And so I would expect that there'll be relatively few exceptions to the duty to bargain. So if you are in a union environment, you're probably familiar with this from your collective bargaining agreement, but you have these obligations to bargain. There are a number of employers, though, that over the years I've worked with that unionized, but potentially are subject to organizing campaigns and maybe have had organizing campaigns, and the union has not prevailed in those. But obviously, from that perspective, employers are mindful that things like how they're handling returning people to work are going to be issues that are going to be of great importance to employees. So there's consideration as to how they do that from the concept of labor relations management, even for non-union employees. And then, as I said, employers need to be mindful of the potential liability of a concerted activity taken by a group of employees, and there's certain protections afforded to employees there. So not that employers would be expected to react negatively if employees are bringing legitimate safety concerns to their attention, but there is an added protection there from a NLRA perspective, as well as, and we've touched on a little bit, and I'll touch on it some more, obviously, OSHA concerns. The other area that we touched on of concern from a liabilities perspective are lawsuits, right? And so I referenced that, the U.S. Chamber of Commerce had expressed that it's the largest area of concern for the overall business community as we reopen the economy nationally, and certainly at state and federal level. There's potential legislative action to deal with some of these issues. You've all seen that in the press as to whether there's going to be protection for employers, for businesses as they reopen, because there's great concern about tort actions relating to the return to work, class actions as well, whether that be FLSA type issues, whether it be class actions about how an employer may have opened up or exposed employees and or members of the public to safety hazards, and whether they follow proper protocols that are consistent with CDC and other guidance. From the lawsuit perspective, I'm sure you all have seen there's been a fair amount of coverage on this, but a case brought, a tort type case, would be somewhat difficult to bring against an employer because of the causation issue, right? How did the employee and or individual contract the virus, and can it be established that the virus was contracted at the employer's premises, right? So that may be difficult to establish the causation. And in class action type of scenario where there's a lawsuit brought on behalf of a class, one of the requirements would be common issues for the class action. And again, that may be challenging in this type of environment. Nonetheless, there's great concern about those type of lawsuits. Some have already been filed. And the other line of defense for employers is the worker compensation statutes, right? And so to the extent employees may be exposed to the virus at work, performing work duties, then as a general proposition, the employers may expect that the workers' compensation statute would act as a defense from what we call the traditional tort liability, the individual claim brought by the employee against the employer. Now, that would not necessarily stop what we call the carry-on type lawsuits, where, for example, an employee would argue that they've been exposed to the virus at work because the employer failed to have proper protocols in place to ensure the safety of employees, and brought the virus home and exposed family members to the virus with bad effect, and have those family members bring a lawsuit against the employer. So some of those potential tort claims in that scenario would be the provision of appropriate PPE, personal protective equipment, and the employer's failure to do so, and particularly, so for example, in the Commonwealth, where we have sector-specific guidelines and the rest, obviously an employer that's failing to adhere to those, you'll see in the last bullet, the government guidelines, is going to expose themselves potentially to claims that they have failed their employees and are now liable for breaches of those guidelines. They didn't exercise prudent return to work measures. Those would also include, for example, proper distancing protocols, They could include claims that the employer did not properly implement telework or work from home policies. We know that early on, as we transitioned to the remote environment, there was a good deal of concern by some employers about the ground rules, particularly for non-exempt employees, your hourly employees, and how you monitor their working hours while if they're in a position where they can work from home and are working remotely. We still got to track their hours, right? So concerns about how that is all implemented and accounted for, particularly, sort of a class action type wage and hour lawsuit is of concern. Screening employees and the requirement of employers to do that by way of self-certifications and the rest. And then, the general cleaning and sanitizing the work area falls in line with the general OSHA requirement, the general duty clause, to provide a safe environment for your employees. Other potential lawsuits that employers are concerned with, and that we have been working to help employers with measures to protect themselves, include claims brought by independent contractors, right? So those individuals that you may have on your premises performing work that are not covered by the workers' compensation statute, right? So you don't have that level of protection. Employers should take a look at those type of categories of workers and make sure that they've got proper protocols and policies in place. Sometimes independent contractors, you get less control potentially of how they conduct their work on a daily basis, right? And so if you're inviting people into your building to perform services that are not you're not covered, that are not going to be covered by the workers' compensation statute. So you as an employer don't have that type of protection, and perhaps have a bit more latitude to establish their own kind of work rules and rules of engagement, if you will, in the work area, because they're not your employees. And so notwithstanding the fact that you may have requirements embedded with your agreements with independent contractors that they abide by company rules on safety and health and welfare and the rest of it, it's something to be mindful of and to take a look at how you're utilizing those people. I mean, we've had clients, for example, that use independent contractors on off shifts to come in, and whether it's maintenance work or what have you, really need to make sure that you're assessing whether you're exposing yourself to any liability there. What safeguards do you have in place, and make sure you're working with sometimes it's a company that's is providing workers to you, and or individual independent contractors. Suits brought against property owners, right? So there are situations, right? Leased buildings and the rest of businesses are operating at locations that others own. And so clearly there could be potential legal action brought against property owners if safeguards from a building standpoint are not in place. It's something to be mindful of, whether you're one of those that may be involved in that industry and actually be the owner and or leaser of property, but also if you're in that type of building, just be mindful of that in your agreements with your landlords. I've noted it a couple of times now, OSHA and safety issues, but OSHA itself, right, is the regulatory body at the federal level that would be responsible for the workplace. And so you may have concerns about OSHA guidelines and OSHA inspections if there's complaints made, and employees being raising those concerns to OSHA, and you being subjected to an OSHA investigation or at least inquiry. Other liability risks to be mindful of, we've touched on, is the whistleblower claims, anti-discrimination claims, those actions that you may be taking and how they impact the employee population. I'm sure now that we're in phase 3 and largely most of the employers have brought employees back or made plans to bring employees back, we're all mindful of that. And early on, back in the April-May timeframe, particularly, a lot of questions about what do I do with the employee who's 65 years old, who may be, I may have concerns as the employer about bringing that person back into the workplace, knowing that the risk to them is greater, at least from a health and safety health standpoint, if they were to contract the virus. And could I could I make a decision to force that person to stay out, right? So certainly we can't make those kinds of decisions based on age, and I'm sure you all have kind of worked through that, but that's continues to be those type of concerns about anti-discrimination issues as you make decisions about how you bring people back and what your policies may look like should be in the forefront. Wage and hour claims we touched on, but clearly making sure that you're tracking if you're working in a remote environment still and or going to continue to be at least to some degree going forward as we're reopening, how we track our non-exempt employees' hours, and even as we bring people back here, things like time for testing and how we handle that from a wage and hour standpoint. And then we've touched on this, the privacy claims. If you're collecting information now on employees and doing any type of testing, we need to be mindful that we've got certain requirements by way of privacy, and we want to make sure that we're mindful of that in how we operate and the policies or the protocols we put in place. So with that, I am going to open it up to, I think Carolyn is going to raise a few issues, and I'm certainly happy to answer any questions that anybody may have.
Great, thank you, Liam. That was a fantastic presentation, and I know I certainly was taking a lot of notes. You know, I think right off the bat, one of the, well, excuse me, before we get into questions, I just want to remind anybody who's participating, you can submit a question through the question and answer feature, and we'll ask it for you. One of the biggest questions that comes to mind is there's a lot of discussion about employers needing to follow guidance. You also mentioned there's local, state, federal, CDC guidance. So for an employer, which guidance do they follow? And when there's differences, how do they know which one they should choose or which one they should follow?
Yeah, so great question. And I think the answer is going to depend in large measure. It's going to be, well, at a granular level, it will be employer specific, right? Because there may be specific industry guidelines, there may be guidelines and or considerations based on the employer's size. There may be some guidelines and considerations that are based on the employer's location. Do you operate, for example, in multiple states, and are you subject to different state laws or regulations? But I would think, you know, for the Massachusetts-based employer, we certainly have a fairly robust state guidance already out that you want to be cognizant of, depending on what industry you're in, right? Because each of those industry-specific sector guidelines include a fair amount of detail, right? So certainly we want to know that and be compliant with it. And then obviously at the federal level, although the CDC guidance is really guidance and isn't necessarily binding on employers directly, it's something that you would want to be mindful of. And then generally, you know, you have an obligation, for example, under the Occupational Safety and Health Act, the General Duty Clause, to have ensure there's a safe environment for your employees. So you want to be generally familiar with those obligations as well. But I would think you'd start in Massachusetts, particularly with the state guidelines on reopening here. Those will and they do track generally those other guidelines and requirements that you may be bound by. And then, you know, there are some exceptions, not so much exceptions, but there are some other considerations with local boards of health and that kind of thing. So, you know, depending on where you're located and do business, you'll want to be mindful of that.
Okay, great. You know, one of the things you talked about was the employees traveling and their off time and some of the situations that an employer may encounter. Can an employer require an employee to disclose when they've traveled in their off time? And, you know, on the reverse, is an employee required to disclose it even if the employer doesn't necessarily have a formal policy?
Yeah, so very ticklish question, right? In the Commonwealth, you have a fair amount of latitude. Employees are at will. the question of whether an employer can require an employee to disclose, I think the technical answer on that is yes. You could have a work rule that says, hey, we want to know in the present environment if you're going to travel on the weekends so that we can ensure that we're keeping a safe work environment for our employees. Now, whether an employer wants to get into the business of monitoring every employee's comings and goings, I think is a different question. And I would say that for the lion's share of employers that we deal with, I think the answer is probably no. You may want to have a policy that requires employees, for example, to notify you if they are traveling out of the New England area and the New York, New Jersey area, for example. So it dovetails with the governor's directive. You may want to have a policy that requires employees to let you know if they're traveling to known hotspots, right? And then you may want to have protocols in place that if those employees do that, that they know ahead of time that they're going to be subjected, for example, to the 14-day quarantine period, during which they may be able to use sick time and or PTO as an example.
Okay, so I've got a question in, how should employers navigate the balance between a duty to warn employees of a positive diagnosis of a coworker and that worker's right to privacy?
Really tough question. You cannot, it's, as a practical matter, it's very difficult, right? Depending again on the employer and the work area, you cannot identify the employee by name. So you can't say, hey, Liam sitting, next to you has tested positive. But you do have an obligation to talk to that employee, right? So first we deal with the employee who's either tested positive or has notified you that they have been exposed, right? So in either case, you're probably approaching this in the same manner. You're then going to want to talk to or find out, you may know already, depending on the type of environment that you have working, but you're certainly going to want to know who that employee may have been in close contact with, and so those that may work in the same general area, and those employees should then be notified that a coworker has either tested positive and or been exposed, and we would be asking those people then to quarantine, right, and to follow. Essentially you'd be having them follow the CDC sort of self-diagnosis guidelines. I mean, they certainly go to a medical provider on their own as well, but they'll want to be attuned to whether they have any of the symptoms, right? So don't identify the employee by name. Do your best to keep it confidential. You're going to refer to a coworker. Probably the case that is a practical matter in some areas because of the size of the employer, et cetera, that some people are just going to know or figure it out. But you as an employer don't want to be part of that, and you certainly don't want to encourage it, right? So as best you can, you want to keep that information confidential.
Great, that sounds like good summary advice, just no names and keep it confidential. Another question, your presentation notes that one exposure for employers is the lack of a work from home or a telework policy. I think in the last 3 to 4 months, a lot of employers have sort of adapted a telework environment, but don't maybe necessarily have a formal policy. How formal do those policies have to be? And if they have to be formal, is there a place you can recommend people look for samples of formal policies?
I think the answer will depend, again, like a lot of this, on the employer. I would have said before the pandemic that most employers that I dealt with that wanted to have and or had telework policies did have formal policy. So there was some consistency in how they were administering that, right? Now in the present environment, I think there's a fair number of employers that are not ready to commit to a policy yet because they don't know quite what the future holds. I suspect that many businesses are looking at this, and some that may say, geez, we've operated pretty successfully here in a remote environment. Should we be rethinking how we build the widget, right, going forward when this is all done? Are we going to have a workforce now where 2 days a week we're going to allow people to work remotely, which in the past we never would have done? We had a formal policy. It had to be for a specific reason. It had to get approved by, 3 levels of management, et cetera. So I think I have a fair number of employers that are sort of looking at it now saying, we're going to hold our powder on this because we're not quite sure how this is going to look when we're done. But the overlay to it all is, the traditional HR type concerns about discrimination and fairness, and making sure that that we're doing this in a manner that's not going to expose you to a claim that you're discriminating against one group of people at the expense of another, one demographic or one segment of your population. The other place that it comes into play, Carolyn, is on the the disability front, right? So in a traditional ADA type compliance scenario, what is and is not a reasonable accommodation? If you've been operating now in an environment remotely for 4 months and doing it fairly successfully, that may factor into ultimately where you come out can we allow somebody to continue to work remotely as an accommodation to a pre-existing health condition that puts them at risk now of really having a bad result if they come back, right? In the past, an employer might not have said no, might have said no. We have a formal policy that says, it's rare, it's the exception to the rule that you're going to be allowed to work remotely. Now you may have a track record where the employee would at least have a claim, and/or an employee's lawyer, that it's been demonstrated that that person can successfully operate in a remote environment. But those would typically be case-by-case type judgments.
Okay, and so that telework could be an accommodation for certain employees.
Potentially, yes.
So we've got a question from a former associate of yours who, and this is an interesting one. He wonders how you would rank these recent challenges compared to other business disruptions during your career.
Oh, probably the most challenging. I think some employers have been surprised at how well they've been operating remotely. But I think the impact on employers is so different depending on, I had employers from day one that their biggest concern was they couldn't get people to come into work. They were so busy, right? So they were in an essential service. And so they weren't dealing with furloughs. They were dealing with the opposite. I've got to have people in the building, Liam. What am I going to do? People are afraid to come in. And so we were offering pay increases, bonuses, perfect attendance bonuses, a lot, so you had employers that were dealing with that. Like, how do I staff a building when people are afraid to come into work? I'm an essential business. On the other side of the coin, you had employers that, the business dried up almost immediately. And so we're struggling with the issue of, do I furlough people? Do I lay off people? What does WARN mean for me? Does I fall in that category? What's the implication of the federal supplement on unemployment insurance? If I apply for the PPP loan, I put people on furlough, what does that do for the calculations and the rest? So, if I was ranking it, I'd say this is the most challenging, if only because there are so many variables and they impact different employers in so many different ways. It's not one set of rules. So, in an economic downturn where everybody's feeling the same sort of impact of the economic downturn, the issues tended to be companies in the same industrial park having vast, demand crawled to a stop almost immediately.
Well, I don't think anybody's surprised to hear you say it's among the most challenging. Another question we have is, and this is one I've heard a lot. So what should employers do if they've met all the guidelines, they've followed all the rules, taken all the necessary precautions and to keep their employees safe? But what do they do if people just don't want to come back because they're afraid, or even refuse to come back to the office because they're concerned about exposure?
Yeah, great question. And again, there's, like so much of this, there's not a right or wrong answer. I think that the vast majority of employers that I've dealt with, really good people trying to do right by their employees. So they're first and foremost concerned about the safety and the health and safety of their employees and trying to get it right? But then you're going to have some employees, either because the employees are legitimately concerned about their well-being and/or family example, they care for older adults, parents, that kind of thing, and or have relatives, or they have a spouse that's got health issues, whatever it might be. So you may have employees that legitimately are concerned about coming back. And then, you always have the 10% of employees that all HR people know they spend 80% of the time on, right? That are just going to be challenging and pushing on the boundaries. How you navigate through those issues. And so, as an example, I had an employer that had a fairly healthy, when I say healthy, a large group of employees that were older. Great place to work. And because of that, people didn't really retire. They'd like to stay. So a lot of employees that really valued working there, but they fell into the over 60 group, where there was legitimate concern by the employer that, geez, I need these people to come back. We're busy. But I'm really worried, Lee, I'm bringing people back that somebody's going to get exposed, and the outcome is potentially fatal, right, for some people. And so one thing, employers I've worked through, the number of employers taking a look at, hey, are we in a position that we ought to be offering what we call a VSP, right? A voluntary separation program, something like an early retirement plan, right? Particularly if they're in an industry where maybe it's slowed down a bit. We still have some demand, but maybe we've had some furloughs. Maybe we've been considering some layoffs. We're not quite doing the same business we did before, but we are bringing people back, but we need to potentially look at a restructuring down the road. So we might look at a VSP to see whether there's a program we can roll out where people might voluntarily decide to retire, particularly if there's some of those individuals who might have concerns about coming back to the same working environment. And that often is also the case with employers that may be, as I said, looking forward and saying, the way we do business may have been fundamentally changed by all of this. And as I look forward to 2021 and 2022, I may need less people. Maybe I had more staff than I need. Now I'm going to be operating in a remote environment, whatever it might be. And so, employers are getting creative as to how they sort of tackle those issues.
So a lot of our discussion's been about from the employer perspective. I'll ask a question from an employee perspective. What do you do, set aside the employers that are doing the right thing and following all the guidelines, protecting their employees. What if you're an employee who your employer maybe isn't necessarily, clearly doing something against the guidelines, but maybe is pushing the boundaries of good sense. So requiring you to travel to California or Texas or Florida right now. What can an employee do in that situation? Do they have to go?
Yeah. So depends upon the relationship, I guess, right? The employee, their comfort level, what the management structure looks like, and the rest, right? I mean, I would always think it is best in the long term, both for the, and I don't want to be Pollyannic about this, right? But if the employee wants to stay with the company and is generally happy in their employment, but has a legitimate disagreement with a particular policy and or approach of a supervisor or a manager, can the employee raise it internally in a way with HR or what have you that it gets addressed, right? If that's really not in the cards and is not really a practical solution, there is a hotline now available in the Commonwealth that an employee can call and remain anonymous. And the AG has been fairly out front on this, right? Been 1,000-odd complaints registered through the AG's complaint form. Again, that may be a vehicle that the employee can pursue without filing a formal charge or going down to OSHA and, registering a complaint in that way, right? File that charge. And then typically what will happen is whether it's, the AG or one of the state agencies will reach out to the employer. And as we all know, from the employer perspective, the ramp up on enforcement of these things is generally there's a verbal consultation, and then we're talking about $300 fines and potentially, like a cease and desist order. Excuse me. I want to come back, Caroline, because I'm not, as I reflected on, I think I gotta I'm Irish and a lawyer, so I tend to talk a lot and fast. And then I recognized I might not have fully answered the question before that, which was about the employee says, hey, I'm worried about coming back to work. And I started talking about, from a larger context, VSP programs and that kind of thing. But at a very granular level, dealing with a specific employee, there will unquestionably be the case, right, where the employer is bringing everybody back, and one employee doesn't want to come back or fears coming back. And ultimately, if that employee cannot return and the employer can demonstrate that we really can't have that employee working remotely, it doesn't work for us, then it's quite possible that you end up separating an employee because they're just unable to return. Now, there are some protections, right? This is where on my slide I talked about the ESL and the Family Medical Leave Act and the changes to law as it relates to childcare obligations and the rest of it, right? So you want to be mindful of all those potential time off benefits that might be available to an employee. And an employer would generally be, I certainly would advise most employers to allow people to use their PTO and or sick time. So example, be flexible as you can be with those types of employees. But if you get to a point where somebody has no more time off and they refuse to and or just won't come back to work, and they're not the type of employee that you're going to invest in like an unpaid leave of absence for some period of time and ultimately try to return them, then it may be that you've reached an end point of the employment, and that technically can be legal.
Okay, I think we have time for one last question, and I'll ask one that touches on the tension between, for employers, between the landlord-tenant relationship. So if you're in an office building, you have doorways, you have common areas, you have your own particular space. Who's in charge of cleaning and sanitizing what, and does that vary from place to place? I think of things like the doorways that lead into an office, the handles. Is the tenant or the landlord going to be responsible for that? And who do employers work with on those situations?
Yeah, I think the short answer is both. Because, well, first, just as a, from a substantive perspective, do the right thing, right? So, employers want to be, they want to make sure they do everything they can to keep their employees safe, right? And so, and the governor's orders and the guidelines that are in place are going to require that, right? So, but the landlords recognize their obligations as well. So common areas like the elevator banks, the entry into office buildings, think of that, right? That's typically going to be in the purview of the landlord to be in control of that. Once we get into the office environment, so you get off the elevator on the third floor and that's your company office suite, right? So the landlord would have some responsibilities there in the common area and even in your area. And typically I think what we're seeing right now is a ramp up on disinfecting and cleaning and having those cleaning supplies available and the rest. But it is the very rare employer that I've dealt with that, sort of looks at that equation and says, okay, landlord's got it, I'm comfortable, right? They're going to want to have their own protocols in place, right? And work closely with the landlord on that. So whether it's supplies or how often things are cleaned or how often the bathroom is cleaned and the rest, the answer is it's a joint effort. I guess at a granular level, who's responsible for what particular area may differ depending on the type of building you're in and the environment. But I think it's certainly from a liability standpoint going to be a joint requirement, right? If an employee gets sick and or you're facing one of those tort claims I talked about before, it's potentially brought against both entities. And if it's an employee where there's a workers' comp bar, then certainly the claim may have to be against the landlord and or the third party cleaning crew, right? Those are the kinds of liability issues that are going to arise.
Great, thank you. I think we have a list of about 50 other questions that we could ask on this topic. It's so detailed and nuanced. But Liam, thank you for your time. It was an excellent presentation. You provided some excellent answers for people, and we appreciate it. So thank you to everybody for attending. We hope it was worth your time and you started to get some answers to your questions. Thanks,
All right.
everybody.
Thank you.
Thank you, Liam.
Bye-bye.